I had two interviews last week. Both of them were naturalization. Um, both of them were ultimately approved, but there were some issues in both cases. Um, in one case, one of my clients um, basically insisted on traveling outside the US close to the date of her interview, and I had advised her do not do that unless the travel is absolutely necessary. There's just so much going on right now in immigration that, traveling outside the US is risky. Even traveling inside the US is risky because we recently learned that the TSA is sharing information with ICE and CBP about passengers who don't necessarily have valid immigration status. So even domestic flights carries an amount of risk, but for sure, international flights, um, you definitely need to proceed with caution, especially if you don't have a valid immigration status right now, if you have something pending with immigration, even clients who are, green card holders, there's no guarantee that you'll be able to travel and re-enter the US with no problems. Um, a green card holder gives you certain protections, definitely, but it's not the same as being a US citizen. And even US citizens, right? There have been accounts of US citizens being arrested by ICE, detained, accidentally deported. So don't just assume that because you have a green card that you will not run into any issues. Anytime someone is leaving the US and seeking to re-enter the country, they're presenting themselves for admission into the United States. So CBP, who are the immigration officers at the airport, they have the authority to assess whether or not someone is admissible into the country. And there have been many times where um, green card holders may have been able to travel in and out the US without any problems, but ultimately, CBP finds out something about their records that they didn't notice before or didn't think to look into before. And lo and behold, they find out that, someone was arrested a while back and that there is a criminal matter. Or they put two and two together and they realize that USCIS granted someone a green card that shouldn't have been granted in the first place. So a lot of the time, it doesn't come on the radar until someone decides to travel, right? Because then you're kind of like opening up yourself to this inquiry. Um, so with this particular client who was scheduled for Nat's naturalization interview, um, I advised her against traveling, and she ultimately decided not to take my advice. And then guess what happened? Trump decided to go after Maduro, right? And as a result of this action, the airspace in certain areas of the world was, um, you know, uh, the airspace was, made it so that people living in certain areas could not travel, right? Planes could not fly. And this happened to her. Um, it's a stroke of luck and a miracle that she was able to get back into the US in time for her interview. She had connections with certain airlines. I think she had relatives who worked for certain airlines, and she was able to, you know, um, fly three different flights with different airlines just to make it back in time for her interview. So that's, I mean, she let me know that what happened to her, and she literally got in, I think, the day before her interview. Obviously a very stressful experience because this interview was very important to her. It wouldn't have been the end of the world. I mean, at worst, we would have just gone to immigration and said, look, my client got stuck out abroad while traveling, and due to what's happened recently, she wasn't able to get back into the country, and USCIS would have probably just given her a new interview date, but we don't know when that new interview is, et cetera, et cetera, et cetera. So, the client told me later on, I really should have listened to you. So, if you have an immigration lawyer or any lawyer in general, and they're giving you advice, um, try and follow it. There's a reason why we're giving advice to clients, right? We're not doing it to make your life more difficult. We're not doing it to try to prevent you from going on vacation. We're doing it because we're seeing so many crazy things happen, especially in the immigration space. There's travel bans going on right now, that affect citizens of 39 countries. So that was a whole other issue as well, because guess where she was going to travel? One of the countries that were on the travel ban list. So for multiple reasons, I just advise my client, look, it's really risky. If you travel, like there's no guarantee that you can get back in. And I as an attorney, there's nothing I could do to predict what could have happened, to predict that a travel ban would be in place or that the travel ban would be um, amended to add even more countries to the list. Or that the president of another country would have been, taken into this country and that the airspace would have been interfered with. So travel, 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 very risky. The other issue that came up in this interview was the, so basically, the number of trips that my client had taken in and out of the United States. That also came up at the interview because she did not list all of the trips despite my asking her to. Um, there were so many trips that she could not keep track of it. I mean, was there a way to have really tried to get a list taken for immigration? Yes, so you could have just looked at all your passports. And, anytime there's international travel, there's going to be an entry stamp and an exit stamp, right? From the country that you are visiting and the date that you leave. So in the past, when I've had clients hire me for naturalization, we would have just gone through all of the stamps in the passport and try to piecemeal it all together and then come up with a list to let immigration know, what date did you leave the US? What date did you come back to the US? Which countries did you go to? How many days did you spend abroad? And because my client didn't do that, I would say about 70% of the interview consisted of the officer going through their own records to, account for every single trip that my client had taken outside the US. We got really lucky. The officer was very patient. I don't know if every officer would have been as nice to do that. It's your burden of proof when you're applying for an immigration benefit, especially when you've been scheduled to appear for an interview. You need to have all your ducks in a row. You can't just show up and assume that, the officer will then make a copy of any documents that you bring in last minute. A lot of officers won't do that. They don't think it's their job. You should come prepared with copies ready to give to immigration. And if there's any questions on the immigration forms that you left out or provided incomplete information, don't just assume that you can just show up and then just tell the officer, oh, I don't remember. Can you figure it out somehow? Or can you look it up in your system? No, they don't have to do that. That's not their job. Um, so, all in all, we got lucky. I think we had a really nice officer. Any other officer could have said, you didn't fill out this question. You didn't list all your trips. We asked you to do that. Why didn't you do that? You had the time to do that. And they could have issued an RFE, request for evidence, delaying the case, or they could have just said, you know what? You didn't comply by providing us with a completed naturalization application. So gonna deny you just for that. Can immigration actually do that? Sure. I mean, You don't know what kind of officer you will have at the interview. Not everyone is going to be nice and patient. Some of them are, stretched for resources. Some of them, honestly, they are strict, right? So they will review and adjudicate cases, um, and expect that all your I's are dotted and your T's are crossed. And if there's anything missing, then they could say, well, not our fault that you didn't complete this. Um, I tell this to clients all the time. Um, a long time ago, I had a client who went to his green card interview. He didn't have an attorney. He filed everything himself. Um, that morning, I think he forgot and he left his original birth certificate on his like bedstand or table, and he only had a copy of his birth certificate. He showed up to his interview. He had an officer who was difficult. And although everything else was fine, the officer denied his green card because he did not bring his original birth certificate to the interview. Um, and as a result, he had to file the green card all over again, pay the fees, wait the processing time, get scheduled for another interview. And only then, after he hired me, was everything approved. But it just is an example that officers have a lot of discretion. They could be really strict if they want to. And I don't think it's worth the risk to get an officer like that and then just assume that someone else will take care of whatever issue comes up. The government doesn't have to do that, and especially in this administration, you're gonna like see less and less, accommodations being made for you. Um, So that was how one interview went. The other interview was also naturalization. Also ultimately approved, but the interview itself was kind of a roller coaster. And the reason why is because a few days before the interview, my client told me, oh, by the way, a really long time ago, I filed something with immigration and it was denied. Is that going to affect my case? So that was the first time I heard of that. And so as I was prepping the client for their naturalization interview, I said, well, what kind of application was it? They couldn't really remember. So I said, well, it's really important. We need to figure out what you applied for. Why was it denied? Do you have the copy of the denial decision from USCIS? I need to review it to see if it is relevant at all to your naturalization eligibility. Um, so luckily she did keep a copy of the USCIS denial and also the application that she filed. Turns out that it was an N-600 um, certificate of citizenship application. So she was trying to apply for citizenship through one or both of her parents. She filed it without consulting a lawyer, filed it by herself. Um, Immigration denied it, saying that she didn't qualify. Um, so, which is why she decided to apply for naturalization. So we get called by the officer, and that's the first thing that the officer zeroes in on. Because the officer had it in their file, and I could see on the computer screen, yeah, that the decision of USCIS denying the application was up on her screen, and she launched right into asking questions about that. Um, so it was just an interview that like there were all these twists and turns. Um, at the end of the day, I think the officer was trying to help my client because this is the interesting thing about immigration law. So the reason why this officer spent so much time on this previous application was denied is that from the officer's perspective, they can't approve a naturalization application if someone is already a US citizen by operation of law. Um, that's why she really needed to make sure whether or not this previous denial was correct because she wanted to look into the possibility that immigration's decision denying this application was wrong. Um, I mean, we went back and forth over it. We were trying to figure out if immigration's denial was right or not. The officer actually thought that my client was already a citizen. So she even paused the interview, had us wait outside so that she could talk to a supervisor about it. We played out all these scenarios, and to the officer's credit, she gave us all these options. I mean, she said, well, um, I basically said, well, if you really think that immigration's denial was wrong, then can you make a service motion to reopen it and approve it if you think that by law she's already a US citizen? She actually thought about it and said, yeah, if it turns out that our decision denying it was wrong, I can look and see if we can do that. So she was really, I think, taking the time to make sure that the right decision was made. So I really appreciate that. You really don't see that a lot with a lot of USCIS officers. Um, Ultimately, she came back after speaking to the supervisor, and according to the supervisor, immigration's decision was correct. So at that point, I just said, look, I don't really care either way. My client really just wants to be a citizen at the end of the day. So whether it's through an N-600 or an N-400, doesn't matter to us. The outcome is the same, right? For the most part. So um, that's what the officer agreed to do. She approved my client's naturalization, and now they are scheduling her for her oath ceremony in the next few weeks. But, I don't think I've ever had an interview go that way. It just goes to show you that sometimes the cases that you think are going to be straightforward with no issues, they turn out being completely unexpected, right? And the opposite too. Sometimes the cases that keep me up at night, where I'm really worried about what might happen in court or the interview, they turn out like being going completely smoothly. So it's just kind of like the odd nature of immigration law. Is that so many things depend on different factors like the type of officer you'll get, the type of immigration judge, the type of ICE attorney that you're dealing with. Really can make a huge difference in the outcome of the case. So those are two kind of interesting, very interesting interviews. I have a few other interviews coming up in the next few weeks. More and more, I'm getting clients that need help with their I-751 petitions, and these are petitions to remove conditions on residence. So these are clients who received a green card based on marriage to a US citizen, and they were given conditional green cards for 2 years. Um, Under immigration law, if your adjustment based on marriage is approved before your 2-year anniversary, then immigration can only issue you a conditional 2-year green card. So at the end of those 2 years, you have to file an I-751 petition to remove those conditions. So what is needed for the I-751 to be approved? Well, you need to show to immigration that you continue to be in a valid marriage. You're still living with your US citizen spouse um, during the 2-year period after you got the conditional green card. Um, Assuming that the marriage is still fine and you're still living together and you have enough proof of that, these petitions usually are approved based on the paperwork that you submit. But every now and then, immigration schedules I-751 interviews. And why does immigration do it and when do they do it? Well, um, some of it is random, Immigration does do, I guess, like quality assurance. So their concern is was the marriage entered into for the purposes of getting a green card? In other words, they're on the lookout for marriage fraud because they know that getting married to a US citizen is oftentimes the fastest and easiest way to get a green card. So they automatically assume that a certain percentage of these cases may not be legitimate relationships. So I've had clients get scheduled for interviews even where the couple was still married and we presented decent to strong evidence of the marriage and cohabitation. So some of it is purely random. They just want to see every now and then, was this a marriage real to begin with? But if you are not married to your spouse anymore, because things didn't not work out, or let's say your US citizen spouse passed away, um, you're gonna face a higher chance of getting scheduled for an I-751 interview because immigration wants to talk to you. They want to hear your side of what happened. They want to see if you are a credible person. They're gonna ask you questions. What happened in the marriage? Um, and they will need to know if you're not together anymore, what is the status of the marriage? Are you separated? Are you divorced? Have you started divorce proceedings yet? The timing of all of this is going to be important too, because if your 751 petition was initially filed as joint, but by the time immigration, let's say, schedules you for the interview or issues a request for evidence, if you're not together with your spouse anymore, you need to advise immigration that this is no longer going to be a joint filing. You need to tell them that you are requesting a waiver of the joint filing. There's four grounds for requesting a waiver. Um, the two most common ones are that the marriage was bona fide at the inception, but that the marriage was ultimately terminated through divorce or death of one of the spouses. That's the most common ground for the waiver. There's other exceptions as well. Um, so the thing is, because 751s are taking roughly about 2.5 years for immigration to process, a lot can happen in those 2.5 years. Um, you may have been together at the time that you filed it, but by the time immigration came around to looking into your case, your marriage is on the rocks now. So what do you do? I would say if you don't already have a lawyer at that point, lawyer up, especially if you have been called for an interview, right? You need to know how to prepare yourself for this type of interview. You need to have legal representation. If immigration issues an RFE asking for more evidence that the marriage was genuine, how do you respond to it? What kind of evidence are they looking for? Um, because what happens if immigration denies your 751? Guess what? Your green card resident status is terminated. What happens after that? Normally, immigration places that person into deportation proceedings because you don't have status anymore. So, I would say if you're dealing with a situation like this, definitely look into hiring an attorney who has experience with 751s, because chances are pretty high that if the 751 is denied, a notice to appear to place you into removal proceedings will probably follow. That usually is what immigration does, you know. And then I guess the next question I get asked a lot is, well, what happens if that does happen to me? If I get put into proceedings, what do I do? What are my options? I'm just gonna give a brief overview because it does kind of get complicated, but you do have the right to have a judge review your 751 de novo, meaning, even if immigration made a bad decision, an adverse decision, um, you can request that an immigration judge review the decision of immigration. Um, you can also ask the immigration court for more time if you have filed a new 751 with USCIS. That's something I've done in the past for clients. Why would I refile a 751? Well, oftentimes when clients come to me with a denied 751, it's because they didn't know what evidence was needed to submit to immigration. So after they consult with me, I explain to them, look, you really need to think of all possible evidence that you can show that your marriage was genuine, that you really intended to share a life with a partner, right? Simply, a lot of clients may not know, like what kind of evidence can demonstrate this. So, I've had clients that were placed into immigration court proceedings. I filed a stronger 751 petition with USCIS. USCIS then approved that second I-751 that I filed. And then we go back to immigration court advising the immigration judge, look, the first 751 was denied, but we filed another petition with much more evidence, and USCIS ultimately granted that. So, 751s can be a landmine, so just, I can't emphasize strongly enough the importance of having an attorney who has the experience in how to handle these cases.